Maximum of 26 years in prison. It's my understanding he was arrested on the 12th of June and that he is currently being held at no bond. I understand that it was inaccurately reported that Mr. Howard was a registered sex offender. I want to be clear, that is inaccurate information. Mr. Howard has never previously been designated as a sex offender. I'm not sure where that information came from or how it began to surface. However, in the press packets that you all will receive today, you will see confirmation of that from the Florida Department of Law Enforcement Sex Offender Registry, in addition to the fact that in 1999 and 2017, this office has previously addressed the fact that Mr. Howard is not a registered sex offender. Notwithstanding his status as a sex offender, the charges presented here are very serious, and my office will take them as such. This case is currently being handled by the chief of my sex crimes unit, and decisions regarding these charges will be forthcoming. There have been questions with regards to a case that he had recently been released on, which was a carjacking with a deadly weapon. I want to take a moment at this time to go through the timeline regarding that offense and why charges have not yet been filed by this office in that case. He was arrested for carjacking on May the 4th. Our victim advocate noted that we were unable to contact the victim because no contact information for the victim had been provided to us by law enforcement on the 10th. On the 12th, we received a case packet from law enforcement. Again, there was no contact information for the victim provided. On the 31st, the assistant state attorney reached out to law enforcement, again requesting contact information for the victim. On June 1st, our investigations unit began trying to attempt to locate this victim, and there were no results. On June the 5th, in accordance with the law, the defense filed what is commonly referred to as a 33-day motion. It is a motion for release on recognizance that the defendant is entitled to if the state does not file charges at that point. Because our efforts to contact the victim up until that point had failed, we were unable to state a good faith basis for contesting the defense's motion at that point. The law regarding release on recognizance after 33 days will also be provided in your press packet. As in previous discussions, it's important to note the difference between the law enforcement standard of probable cause versus the state attorney's standard of beyond a reasonable doubt. Law enforcement, upon interviewing a witness, found probable cause to make an arrest. However, in this particular case, as in many cases where you will find that the charges are later not filed or dismissed, the state is unable to contact the victim or have willing participation from the victim. And in any case where there is a victim, unless there is substantial evidence in which the state can go forward without the testimony of the victim, the state cannot proceed with charges because they will be unable to prove that case beyond a reasonable doubt. This case was specifically unique because both the defendant and the co-defendant gave stories or testimony that aligned but conflicted with the written statement of the victim in that case. It was an imperative that we made contact with the victim so that we could verify his statement, and we were unable to do so in the time that is provided by law. Therefore, we were unable to move forward with charges at that time. That case is still pending. And in the event that we are able to make contact with the victim, we will assess the strength of that case at that time. However, in accordance with the law, the state could not, in good faith, contest the defense's motion for release on recognizance and the court granted the defense's motion, and he was released, as has been previously stated. It's also important to note that Mr. Howard has more than 3 decades of history with the criminal legal system. His first arrest that I have been able to find was dating back to 1985. He was sentenced to prison in 1986, in 1989, in 1997, in 1999, in 2005, and according to the Department of Corrections, again in 2019. Upon being released in 2019, the offenses that we've discussed here took place. Based on Mr. Howard's history, there is certainly a concern as to whether or not or what type of danger Mr. Howard poses to our community. And the prosecutors in this case will certainly take those things into consideration in making charging decisions and resolution decisions as this case moves forward. At this time, I will open the floor for any question. I'd ask that you'd raise your hand, state your name and your station, and wait for me to call on you. Yes.
Hi, Jeff Left-Coolidge from WFTV. You had mentioned it yourself just now about taking in the totality of this guy's record. So how do you keep somebody like that off the street if you don't keep him in jail for the evidence that you have to charge him, let a grand jury decide if there's enough evidence to hold him to trial?
Yeah, so the law doesn't work that way at all. There is no grand jury that decides anything in a case that does not involve a first-degree murder in the state of Florida. Furthermore, the law prescribes certain time limits for certain offenses, and there's nothing in the law that says we are going to do something that's extra than what's prescribed to keep someone off the streets. The only ability that we have is to charge people for the offenses that they commit and seek sentences that are fair and just under the circumstances of those cases.
Valerie. Hi, Valerie from Fox 35. Do you think the law should be adjusted? And if so, would you do anything to start that process?
Well, if you say, do I think the law should be adjusted in which regard? Because there are many regards in which I think that our laws should be adjusted, but what specifically are you referring to?
In regards to the long criminal history, he is in prison several times. And so to see this, and then to see this new carjacking charge, should there be something in the law to state that maybe the time could be longer, where he could be held, to give you more time to find what you need? So
you're saying the law with regards to his release on the carjacking, that he shouldn't be permitted to get out within 33 days? Well, I think if you look in a case where someone is guilty of a crime, then I think that people might, think that that's the case. But as I've stated in this particular case, we don't know whether or not this individual was guilty of that crime. So in a case where someone is not guilty, should they be held without bond for more than 33 days while the state is able to locate a witness or a victim? I think that many people would think that in the case of individuals who aren't innocent, and people are presumed to be innocent until proven guilty, that necessarily shouldn't be the case.
But if you look at the totality of, since he was let out in 2019, 2020, he's been arrested 7 times. He keeps getting out, and some of the cases you didn't prosecute those cases. The other ones he got maybe few days in jail because he had time served, maybe a couple weeks in jail for time served. So how do you keep somebody that just doesn't care, keeps getting out and committing more crimes from keep getting out and doing more crimes?
So we look at each case on an individual basis, and the prosecutors make a determination as to what is the most appropriate charge for the case that they are currently reviewing, and that's how you do it.
But do you always need the witness for this thing? The police had body cam of all the interactions with these people and had their statements.
So yes, you do need a witness when there is a victim for a crime. In order to prove a case beyond a reasonable doubt, you need a witness who will come in and say, these things happened to me. Unless there's video surveillance that actually shows the crime taking place, then you need a witness to come in and say, I am the complainant in this case, and these are the things that happened to me. Yeah.
Catherine Silver with News 6. Is there anything any words you can offer to this recent 18-year-old victim and her family? I imagine that them hearing that, you couldn't contact the witness from the previous case is not enough when he did get out and then days later she becomes a victim of a crime.
So the state attorney's office is going to follow the law in every single case. And it's important to understand that we don't release people and we don't incarcerate people. We only follow the law where it comes to processing charges. And in this case, the law states that if we didn't file charges within 33 days, that the defendant was entitled to release. And we were not able to file those charges because we weren't able to prove the case beyond a reasonable doubt at that time. And while I understand that certainly that's of no consequence to an individual who has now allegedly been victimized, that is the state of the law, and we are going to uphold the law in every single circumstance. So I can't comment specifically about the facts of that case because that is an open and ongoing investigation, but it's important to note and understand that in this case, as with every case, the state attorney's office followed the law.
So what happens if, in this case, he gets, he's only being held on the charge for the carjacking with no bond?
Mm-hmm.
You drop that case, and then he's able to get out on the latest charge, which is the attempted rape, and that person doesn't come forward, and then he's let out again. What do you say to the next person who he victimizes?
I don't know what you mean, what do I say? But what I would say to the community is that the state is going to follow the law, and we will not go forward on a case that we can't prove beyond a reasonable doubt. And while I understand that is frustrating when you feel that you have someone who's dangerous or has been proven, or not proven, obviously, but shown to be guilty, the reality is that people are innocent until proven guilty. And if the state can't prove the case beyond a reasonable doubt, then we can't presume guilt because the Constitution doesn't allow that. So we're going to follow the law in every single case, and we're going to do everything that we can to ensure the safety of the community. But as I've said on several occasions before, that community safety begins before these incidents take place, not after, because the only thing the state can do once we receive the case is respond to it. We can't stop it from happening. And that's why my administration has been involved in so many community activities and where we can work on reducing violent strategies in our community so that we can stop things like this from happening. Yeah.
This suspect's history is notable. So if we can't keep people behind bars and we can't rehabilitate them, what does that say about our community?
What evidence is there of an effort to rehabilitate this individual? I know that he spent decades in prison for sure. So I think that speaks to whether or not prison in itself is rehabilitative, but I'm not aware of any evidence that we've ever done anything to attempt to rehabilitate him. Yeah.
How does this all make you feel, seeing this, knowing he has a long criminal history and seeing what had happened?
I think as a community, this is a really sad day. We're seeing an individual who has more than 3 decades of interaction with our criminal legal system and has spent lengthy periods of time, I believe, in reviewing his records. I've seen a sentence as long as 15 years incarceration, and we still haven't seen a change. I think as a community, we should all be sad and looking for ways that we can address individuals like this effectively, because what we've done thus far hasn't been effective. All right, thank you all for coming.